My name is Daniel Schaffner. I'm attorney for the appellant in this matter. We're here on a foreclosure matter right now.
It's a rather interesting foreclosure because while the mortgage is signed by the husband and wife, the note's only signed by the husband.
That is correct, Your Honor.
There's no evidence in the record, to my knowledge, of the trust, and Wells Fargo is a trustee.
That's been one of my complaints.
Well, and it's a good complaint, because if the trust doesn't give Wells Fargo the right to litigate, then they're out of court. Moreover, summary judgment perplexingly was entered in this case when the case was not at issue. There was no answer and no default.
And I had a motion. The judge had, and I'll go over this. The judge had, we had a hearing. The judge says you have 10 days to file an answer. This is after a motion to stay.
He says that verbally.
Yes. And I've been doing this for over 40 years, 40 and a half years. And for 40 and a half years, a judge said that 95% of the time I filed an answer within 10 days. When the record doesn't support an answer being filed, when the rules require, they're in my motion to dismiss, paragraph 5, page 98, I noted to the court, and there was a scrivener's error, no assignment of the note or mortgage, no endorsement of the note, no assignment of the mortgage.
I hate to spin into the abyss, but the note, and I'll ask your opponent this question as well, but the original note and mortgage was from Fremont Investment and Loan, correct?
Correct, Your Honor.
So that's not a legal entity, is it?
I think it was a mortgage.
As an officer of the court, can you tell me what Fremont Investment and Loan is?
I'm not relying on it.
We don't know if that's a partnership. We don't know if that's a corporation.
I think you're right, Judge.
And quite honestly, I'm not sure that a non-legal entity can make an assignment of anything.
Right.
We know the assignment in this case on the note, for reasons that escape me, was on the back of the note when there was plenty of space on the front of the note. But there's no evidence in this record, at least to my knowledge, when the assignment was made.
And not in the affidavits of indebtedness either. And the court and Bank of America funding.
And let me give you my last salvo, and then I'll hopefully be silent. The plaintiff in this case alleged in their complaint as officers of the court, and let me take a quick look at something just to, I'm not quite sure why their complaint needed the names of 7 lawyers on it, but it did. And they alleged, and I quote, "The conditions precedent have all been met." And that's not true.
And I would also note to the court, the face of on the note, it specifically references the condition 22 of the mortgage, acceleration of remedies, and all that. The note on its face shows a condition. They've argued, and they've argued before this court in their brief, and rely on the fact that it's a negotiable instrument. They claim I've waived everything. Judge, the waiver is a product of their non-disclosure. The assignment of mortgage in violation of Rule 1.080 was never provided me. I had no idea there was an assignment. I argued motion to dismiss. I was dumbfounded when the judge gave me summary judgment.
I can't, because the assignment on the back of the note is allegedly, it's from Fremont, right?
That's correct, Judge.
Okay. But even in their complaint, they allege that MERS was a nominee, which I think is a fiction. I'm not sure what a nominee is, but
it's a banking setup.
I know. But they also allege that MERS is a mortgagee. Now, if MERS is the mortgagee, then MERS had to make the assignment. Isn't that right, or am I missing something?
Well, that's right, Judge. If they are...
That's what they alleged. I don't think it was true, but that's what they alleged.
Well, the assignment of the mortgage, I thought MERS signed that.
I thought it was signed by Fremont.
No, I think MERS signed it, but I think...
Oh, on the assignment of mortgage?
Right.
Yes, well that is a document indeed signed by MERS, which brings us to a more perplexing point, that the assignment on the note is from Fremont, but the assignment of the mortgage is from MERS as nominee, but it's dated 4 years after the alleged effective assignment.
And 23 days after the complaint was filed.
Well, and that's why I think it was done, because a cause of action has to exist at the time the complaint is filed.
By this court.
By Feltus and other cases of this court, you can't create a cause of action after you file the complaint, and that's what this assignment of mortgage looks like it's trying to do.
And again, Judge, I have spent an insane amount of hours on this case because it was so difficult to understand, and I believe it had a significant public interest. I put here Pinto in my reply brief. I know that it's a case involving a bogus assignment of mortgage that was in front of the 4th District. It's now pending in the Supreme Court. The assignment of mortgage was no good, but they presented it as a valid assignment of mortgage, and they never went to judgment. In this case, we've got a bogus assignment of mortgage. They literally consummated their, what I believe is blatant fraud upon the court. And I believe this is systemic to the system in these trust cases. Many judges, and with articulation much better than mine, have articulated how it's an interwoven sheen that no one can, find the answers, let alone trial judges that's got hundreds of thousands of cases statewide. I hyperlinked to the website showing this trustee in this case is sitting on what they claim to be bearer notes, $897,392,000 that they're enforcing in Florida and the rest of the states. I understand from general knowledge there's somewhere between $6 and $10 trillion worth of these trust mortgages out there. Now that may be high, but there's nearly $1 billion in this one trust, and they're not playing by the rules. They didn't.
Well, you would agree with me that few cases in the law are simpler than a mortgage foreclosure when you don't layer in assignments and if you have a loan from Smith Mortgage to Joe Blow, and Smith holds the paper, and Joe Blow defaults, Joe Blow's basically only defense is payment.
I agree, Judge.
It's a very simple process. But when lenders bring upon themselves assignment upon assignment, and they bring in entities they call nominees, and they don't record assignments on the public records, and an assignment of a mortgage is from a different party than an assignment of a note, and you don't have a trust instrument, it creates a problem.
And I respectfully submit, Judge, that it wasn't that difficult to do this one right. They knew they did not have an assignment of mortgage. It was filed when they had none. They after acquired it. They're charged to know that.
And see, that's the problem, because some borrowers' counsel believe that the obligation is going to go away. In almost no circumstances that's going to happen, but it does have to be filed correctly.
And it'd be nice to know you're paying the right party. Yeah, as I understand it, the investors have paid for, bought. Merrill Lynch has no money in this. The investors bought the notes. Merrill Lynch now is acting as trustee. I question whether Merrill Lynch has authority to do that, Judge. If as I understand it, in these negotiable instrument litigations up in New York, these investors have sued these various brokerage houses, and they got back maybe 30 cents on the dollar or whatever. This might be a case, and there's no way to tell from the record. All I know is there's no way to tell who's the right party to pay, and I don't believe the banks have any dollar invested.
We obviously see a lot of foreclosures, and we see a lot of foreclosures where the loan was made April 1 of 05, and the party either never made a payment on the loan or made 1 or 2 monthly payments and then has lived mortgage free for years. Your client actually paid on this loan for 4+ years.
That's correct. And again, and times got tough, but then I got penalized for moving state. I tried my best to negotiate a settlement, and I was asking to reduce that principal down to the present day valuation, and we're out of here. And they didn't work. And I'm not a foreclosure expert, Your Honor, but I have done a lot of catching up by killing myself because I felt the integrity of the judiciary was at stake. If this court would find, and I don't understand why that hasn't been done, that just on these notes that tie into the condition precedent, which this court handled in Lucy Bank. I know that the issues were different. I read that in the answer of my opponents. They says, well, that was 3 days. They didn't give them time. Well, as I understand, and I got the definition in my initial brief. The definition says an unconditional promise to pay a sum certain. The note says it's subject to Rule 22. That's conditional. It's not a negotiable instrument. It's not a bearer note. And they're trying to pass off these mortgages. They find themselves in the possession. They're trying to pass them off as, demand notes. A dollar bill is a demand note from the Federal Reserve.
Well, let me ask you a question, too, in this case. When the case was filed, Wells Fargo couldn't have gotten a judgment because the exhibits to the complaint contradicted their ownership of the note and mortgage, correct?
I argue that prolifically.
Okay. And then they come along and they file what they deemed to be a supplemental exhibit. Now, a supplemental pleading by the Florida Rules of Civil Procedure requires a motion, but they never filed a motion. They just filed this, and they tried to mask it as an amended complaint. But they never filed an amended complaint, did they?
No.
Okay.
But, and this waiver argument, Judge, they withheld the very documentation that would allow me to defend the case. Now, when I filed that motion to dismiss, under the rules it was proper because no assignment of mortgage or endorsement. And if they wanted to say I waived anything, I believe they waived the right to allege that by virtue of their not moving to strike. But if they would have moved to strike, I would have brought all that up. Then they would have been caught having to expose to me the assignment of the mortgage, which I would then said, this case is out of here. I mean, I believe...
That's not necessarily true, is it?
I believe so, Your Honor.
Well, we have an opinion of our court called Taylor that discusses an equitable standing, and it says if you can show that you are the owner and the holder of the note at the time you instituted the lawsuit, you have standing. So the first part would be if the assignment does it, and if that fails, you're correct. There's still a secondary position that they could arguably attempt to establish. I'm not suggesting to you that they did that here.
I'm familiar with that case. There is nothing in the trial record, and they did not file an equitable.
I'm just saying, theoretically, that avenue.
Theoretically, that's correct.
We're on the same page.
But there's nothing in the record that would allow them to. They did not even file an equitable count. I mean, they relied on that. What I believe is to be a disingenuous promissory note that they're trying to pass off as a barren note.
And just so you know, you've got 5 minutes left. You can use it for rebuttal, or you can use it any way you want.
Well, I'll use 1 more minute for...
Okay.
I would also ask this court to note that because of the, I believe, the significant public interest in getting these cases, congestion in the courts, that the court consider, if it does decide this is sanctionable conduct, I would ask the court to consider the sanction be measured by the $897,392,000 amount of bearer notes they claim they hold, not by the $185,000 mortgage case. 30% of the foreclosures are on the way of default, and they can't prove this case.
There's not a court order default in this case, is there?
No, Judge, and I had trouble.
Appearance, so there's no clerk's default. They couldn't do it. You would need a court signed order of default, wouldn't you?
Yes, Judge. And I mean, there's just so much. I've had a very difficult time preparing for this because
I'm not trying to take up all your time. Just make sure on the record there was no.
I just reserved 4 minutes.
Up 4 minutes left.
Thank you, Judge.
Ms. Matson.
Good morning, Your Honors.
Good morning.
A lot to cover, and I feel I need to explain some things. But the first thing that I wanted to highlight is the issue of the no default and the no answer file.
Let me take you through that. The judge verbally says you've got to file an answer by July 5.
There was a written order entered, Your Honor.
Okay, but there's never a default. You've got
No,
a default.
there was no default. We submitted the status of the case was this. The defendant filed a motion to stay initially back in November of 2009 after service. It was never served on our office, so we didn't know about it. We filed a motion for clerk's default against the parties, and it was returned to us by saying that there was a pleading file.
Let me see if I can short-circuit it. This case was not at issue when the summary judgment was entered.
It was at issue because there was a court order that ordered him to file an answer by July 5th, and instead he made the tactical decision to instead file a motion to dismiss.
It doesn't make the case at issue.
No, it doesn't. The case can only be at issue if there's an answer or a default. And it was not a mysterious yellow brick road that would have prevented Wells Fargo from obtaining a default or compelling an answer, but they didn't do it.
No, Your Honor, but I don't believe in moving on a motion for summary judgment, it's not a requirement that all the parties be defaulted. It would be a default judgment.
Is there any authority that summary judgment can be entered when a case is not at issue?
That I don't know, Your Honor. That I don't know.
I'd be hard-pressed to think of such a
But the motion to dismiss was scheduled for hearing at the same time as the summary judgment, and the court denied it. And because the court had already ordered them to file an answer by July 5th and they didn't, the court didn't grant them additional time to file an answer.
But the court would have had to default. Here's from this court, Howell versus Bebb. If a plaintiff moves for summary judgment before the defendant has filed an answer, the burden is upon the plaintiff to make it appear to a certainty that no answer which the defendant might properly serve could present a genuine issue of fact. Now, among a multitude of items of genuine issues of fact is that in your complaint, and I say your, I don't believe you signed it, but perplexingly to me it had multiple names on it. There was a paragraph that was captioned condition precedent, and it said all conditions precedent have been met. Now, it's not hard to know if you do mortgage foreclosures that you need to comply with the acceleration clause. And that was never done by Wells Fargo, was it?
It wasn't raised as an affirmative defense, Your Honor.
No, wait. My question is, Wells Fargo never complied with the acceleration clause, did they?
I can't say because it wasn't raised and I didn't ask my client to provide me with the demand letter.
Now, hold on. Your firm specializes in mortgage foreclosures, right?
Yes, Your Honor.
And every mortgage that I know of has an acceleration clause, right?
Yes, Your Honor.
And so before you file the mortgage, you send out the certified mail letter saying, this is the date of the default, this is what you owe to bring it current, and you got 30 days, or we're going to potentially file a foreclosure.
Absolutely.
That's a condition precedent, and in your complaint, you captioned a paragraph, either 4 or 5, saying, bold print, condition precedent, and you, I mean your firm, said all conditions precedent have been met.
Correct.
So as an officer of the court, the signatures on that complaint represented that all conditions precedent had been met.
Correct.
And it wasn't true, was it?
No, it was true. And I haven't seen the letter, but
Do you have the acceleration letter?
Are you really suggesting that you don't know?
No, I'm suggesting that we have, when our client...
Listen to me. You're not telling us that you don't know whether the acceleration letter was sent or not. I hope you're not saying that.
No, I'm saying that when we get a referral, it shows us on the information that we receive from the client that when the demand letter expires.
You know it was not sent, don't you?
I've never in my 15 years had a case where a demand letter was not sent.
Do you know, Judge Black has asked you, was it sent in this case or not? Yes or no? That's a very simple question.
No, I understand that, but I have not seen it because it wasn't raised as an issue in the case.
So you're saying because it wasn't raised, you don't know the answer to that question?
I would have to say that I would rely on our business records on the referral that stated when the demand letter expired. They tell us the demand letter was sent and when it expired.
Once it's raised in a brief, if in fact you had such a letter, you would mention it somewhere in the record, in the briefing, somewhere?
No, because it wasn't preserved for appeal. It wasn't raised as an affirmative defense. There was no obligation on our part before the summary judgment hearing.
So because it wasn't raised, you don't know. You just didn't. You figured, why bother to look?
It wouldn't change. It couldn't affect the outcome. I can't bring evidence at the appellate level.
Well, here's something I don't understand. Is when I represented multiple banks as a lawyer, and I always sent the acceleration letter. And I had a paragraph just like you have, and I said, attached is Exhibit A, which is the acceleration letter. You made the bold assertion, but there's nothing attached. There's nothing in this record.
I agree, Your Honor, there's not. But from a pleading perspective, that's all that's required. The pleading rules of civil procedure allow you to make a general statement that the conditions precedent have been met.
You know as an officer of the court is not true. They allow you to do that.
They allow you to do that, yes. And I'm saying...
If you know, as an officer of the court, that there was no acceleration letter, you can allege it. Is that true?
No. If I knew that there was no acceleration letter sent, I could not allege it.
Okay.
But when we receive a referral, it indicates when the demand letter expires, because that's the important date. You can't file the foreclosure until that 30 days has expired. So that's part of the information that we get. We don't necessarily ask to see the letter unless it's raised. And it wasn't raised in...
There's no independent investigation to determine whether or not the client is correct.
I'm sorry, Your Honor?
There's no independent lawyerly viewing of the client's file to verify that the client's representation is correct.
No, we have to accept their business records as being accurate at some point. Otherwise, we would have to go into every single one of them to counter it. And like I said, in 15 years, I've never...
Somebody's signature on the complaint.
Right, and they would have reviewed the referral that came in that indicated when the demand letter expired. We have to rely on that. There's no way to go behind, and we don't really get a copy of the letter unless it's raised as an affirmative defense. And again, the rules allow a generalized statement of conditions precedent, and in this case, the defendant was ordered to file an answer. He could easily have raised that as an affirmative defense. He had 30 days from the time he filed the motion to dismiss until the actual summary judgment hearing to file it. He could have filed an affidavit in opposition and raised that as a defense. He could have filed the proposed answer that he ultimately filed a month after in his motion for rehearing, but he didn't do it.
You would agree with me that a cause of action must exist at the time the complaint is filed, correct?
Yes.
What evidence is there in this record as to when there was an assignment of the note?
I would suggest that there's no specific evidence about that because we did file an assignment of mortgage, but it wasn't filed as evidence because we had possession of the original note endorsed in blank. We pled that we owned and held it, and we surrendered the original note with a blank endorsement.
Note endorsed in blank under the Aurora case is valid, but it has to be assigned to your client before your client files the suit. And there's no evidence in this case when the assignment of the note was made. The assignment of mortgage that we did file, although it wasn't... I'm talking right now about the assignment of note. I'll move to the mortgage.
Correct. There's endorsements on notes are never dated, much like when you endorse a check, there's no date.
When it was done, is there?
No.
Okay. And the assignment of mortgage The assignment of the note was from Fremont.
Correct, because the note it identifies the lender was Fremont. The only entity that could endorse that would be Fremont.
Is Fremont Investment and Loan a legal entity?
I don't know the status
That would
of
be a
Fremont.
problem.
I don't believe they're in business any longer,
That'd
but
be a problem, wouldn't it?
if they weren't,
If they weren't. A non-legal entity can't make an assignment of anything, can it?
well, this wasn't an assignment, it's an endorsement.
That's the one by the senior vice president without recourse?
On
That's the endorsement.
Correct.
I forget the gentleman's name. I'm not.
Yeah, I don't remember
I don't
either,
either.
but yes.
It was without
Yes.
recourse.
Right.
On that. Okay, that's what you're referring to.
Right, and Fremont, I believe, went out of business
And the
a few years after that.
corporate assignment of mortgage says the effective assignment date is August 2305.
Correct. The 2005 is, if you look at the plaintiff's name, it's a series 2005 trust. That trust was established in 2005, and this mortgage went into that trust on that date.
But it's in this assignment is notarized October 29, 2009, which conveniently is 23 or so days after you filed your complaint.
Correct. And if your honors understand what the purpose of MERS was when it was organized,
I think we understand.
no,
I think we understand.
But the purpose of MERS was to eliminate the need for assignments of mortgage, because prior to the securitization, actually, when I started doing foreclosure work, it was ABC Bank, and then they sold it to XYZ Bank, and then they sold it to another one. And you might have 10 assignments by the time it went into foreclosure.
You had an assignment, and you recorded it in the county where the mortgage existed.
Correct.
So it was easy for a title search to find out who
Absolutely.
owned the mortgage.
And that has a different function. MERS was designed for a different reason. MERS was designed to eliminate the need for all of those assignments. And the only time they really do an assignment is when it goes into foreclosure.
Was MERS the mortgagee?
Mortgagee as defined in the mortgage, yes. And they're the mortgagee and nominee for that lender, and it's assigned. So if
They took the place of Fremont as the mortgagee.
as the mortgagee, right.
Okay, so how could Fremont make an assignment when they were no longer the mortgagee?
They endorsed a note. They were still the lender on the note. The lender never changed. MERS is a nominee
Tell me a lender and a mortgagee are two different things.
as defined in these documents, yes,
Really?
and for a different purpose.
So you have the lender on the note, and
Correct.
you have MERS on the mortgage, and that's the operational.
Right, and the purpose, and the MERS was actually set up to benefit the public, because the borrowers would get a mortgage that has a MIN number on it. And the MIN number, if you go to the MERS website, you can call or you can go in, and you will always be able to find out who is servicing your loan. And this was always a big problem before, if they didn't get the notice of servicing transfer and when the loans were assigned. So MERS served the purpose of two things. It eliminated the multiple assignments that might have happened, and it also provided a base where the borrowers could go to always find out who is servicing their loan. So the assignments, when it's a mom loan, a MERS originated mortgage like this one was, you wouldn't expect to see any assignment until it goes into foreclosure. And because the MERS rules say that if it goes into foreclosure, it has to come out. So that's the assignments of mortgage in these cases on mom loans are almost always done after the foreclosure is filed, or at least after it's referred to foreclosure.
If I get an assignment from Fremont, I'm now the mortgagee, right?
If Fremont executed an assignment of mortgage,
The note and mortgage to me. I'm the mortgagee, right?
okay, but I don't mix notes and mortgages.
You don't mix notes and
No,
mortgages?
the notes get endorsed, but the mortgages get assigned. So when you say assign the note, I get confused because I'm not sure what you're referring to.
Let's talk about the mortgage. Fremont assigns the mortgage to me. I'm the mortgagee, right?
Okay. I'm assuming this was not a MERS originated mortgage.
Well, MERS doesn't change the basic rules of mortgage foreclosures. And MERS is not a friend of the borrower. I've seen hundreds of these, and trust me, I haven't seen one yet where MERS was a friend of the borrower. If Fremont assigns the mortgage to me, I'm the mortgagee, right?
Correct?
Fremont has no more connection to that loan, to that obligation, to that mortgage,
To the mortgage.
right?
But you're mixing the notes and the mortgage again, and Fremont endorsed the note in blank, which makes it a bearer note. Anybody who has possession of it can enforce it. The mortgage, MERS assigned the mortgage to the plaintiff. Plaintiff actually had possession of the note. They had possession of the note before the complaint was filed. We did not include a lost note count because it wasn't lost and we knew our client had it.
Assuming that to be the fact, as I look at the record, the document signed by the vice president, Mr. Patton, let's assume that's his name, has no date on it, right? So we don't know from looking at the
No, I agree.
whether it predates the filing. Help me out with the corporate assignment of mortgage. I'm looking at the one from MERS that's in this record. And it says, as nominee, and it just above the corporate seal says, this assignment is effective. I'm not trying to be argumentative. I'm going to say it strikes me as that is a legal conclusion as distinguishing from this document was transferred on such and such a date at such and such a time, and then we make the legal conclusion that it was effective. That's my first concern. And the second was, I'll make sure I understood your earlier argument. Just above the assignment, it says, together with the notes. And you were having me follow two separate paths, note and mortgage.
Correct.
Help me out here.
Okay, the note goes with this assignment, and this entity that the assignee also has possession of the original note, which contains a blank endorsement.
The note doesn't go with this because the mortgage follows
the mortgage follows the note.
The note doesn't follow the mortgage.
Correct. So Wells Fargo was already in possession of the original note and the mortgage followed it. The assignment was done for the purpose of getting it out of MERS and into the entity that filed the foreclosure action and who owned it since 2005 when it was placed into the trust. And I agree, Your Honor, that adding the assignment is effective that date. It's not a custom assignment. It's a standard document that they use, and that's the only way that the preparers could get that information onto the document. It would be nicer if it were a custom document and it said on such and such a date this deal took place and the mortgage was sold into a trust, but they don't do that.
We're doing something on summary judgment where the moving party has arguably a burden of proof because the ultimate result is to deny someone a trial. I'm just trying to make sure I understood what all the documents are and what they're saying.
Okay. No, I understand, Your Honor. And again, it's their form document, and it doesn't provide for that kind of language in a different world, and they could customize everything. It might look different. If Your Honors have no other questions.
With regard, then I'm going to make sure I've got a couple. Actually, I want to make sure on the standing issue. If I understand one of this court's earlier 2011 opinions, you can have, but I think the opinion, I think it was Taylor said, equitable standing. So as I go through the record on this case, the motions, the affidavits that were filed in support, which document would you tell me to look for that would say that Wells Fargo was the owner and holder of this note on a date that precedes the date filing of the complaint? Is there a document I could look at or a series of documents you would direct me to?
There's no specific document that says that. The pleading of the complaint where there's no allegation that the note was lost, we allege that we had possession of the note.
Yeah.
The note that was originally
theoretically after the lawsuit was filed.
Correct. You could. But if we didn't know that Wells Fargo didn't have the note, didn't have possession of the note, we would have included a lost note count. We didn't because we knew it and we knew it was coming to our office. And when it did get there, that's when we made the copy that contained the endorsement and did the notice of filing as an amendment to the complaint to take the place of the copy of the note that we received. What happens is that usually when the mortgage referral, the foreclosure referral comes in, the lender gives you the copy of the note that's scanned on their system that comes from the origination file, which of course it's before it's been endorsed. So that's all we had to work with at that point. But a month later, the original note did get into our office, and it's an unusual situation. But the record shows that we did file a lost note affidavit at one point, and it was by our office because
I thought you said you didn't lose it.
No, we didn't. Wells Fargo didn't lose it. I wanted to point it out because it indicates our policy and procedure in our office, and that we received the original note and it was misfiled. So prior to the summary judgment, we didn't know where the note was. So we filed a lost note affidavit, and it is part of the record. But after that, we did locate it. It was just misfiled.
Is there any legal significance, and if I mispronounce the word allonge or long?
Allonge.
that it appears on the reverse side of the note rather than on the facial
Well, there's a
side.
different, an allonge is actually a separate piece of paper that gets affixed to the note that has the endorsement on it. Those usually are also not dated. This case did not involve an allonge at all. What he was seeing was the endorsement is on the back page, and many endorsements are on the back page at the last page of the note. And the only way to get that on the record is to copy it, and so it looks like it's on a separate page, but it's not.
It's actually an endorsement.
It's an endorsement. It's a stamped, correct. It's a stamp. It's not an allonge.
The only case I've ever seen in 40 years as a lawyer where the endorsement's on the back.
Really?
Yes.
Oh, wow. I've seen many.
I
many.
understand.
Yeah.
Because of the
Yeah.
nature of these loans.
Yeah. No, I do. And I've seen many in the front, too, and 2 or 3 in the front, but I've seen just as many on the back side at the last page. So I don't think that that's unusual at all.
And your time is up.
Okay. Thank you, Your Honor.
You're welcome. Rebuttal?
Yes, Your Honor. I think the court's question just brings out that Wells Fargo filed this case and they had full knowledge they were not providing full disclosure demanded by equity. All cases in foreclosure are tried in chancery, and they had an obligation of good faith litigation practices, and by not filing the material documentations and attaching them to the complaint, showing the note with endorsement, the assignment of mortgage, to verify the allegations of the complaint. Defense counsel is running around chasing air almost. The borrowers rarely have any money. My client being no different. I mean, they're having trouble with their mortgage. They don't have money to stop this volume of paperwork thrown at them by the banks. When the banks play hide and seek with the truth in equity, there should be a sanction. I have now spent over 3 years on this case, or thereabouts, since 2009. It's not right that a borrower is faced with going by way of default. I understand over 30% go by way of default. When there's $897,392,000 worth of these notes they can do that with, they're making $300 or more million just on defaults. And no one knows whether they were right or wrong. I do not give them. Now, I cannot give them excuse. I believe it should be sanctioned. I believe that we stop this conduct with a decision by the 2nd District Court of Appeals. The congestion will go down by 50% or more. This is a game they've been playing. They've never been sanctioned. I don't think I found a sanction more than $750,000. And if they only got sanctioned $750,000 twice in every 100 cases, they would net out. If the average mortgages average $200,000, they'd net out $18,500,000 profit would not have to prove their case if they got sanctioned $750,000 twice in every 100 cases. And I've only found 1 or 2, I believe. I might have quoted the AmeriQuest case. But I just asked the court to consider, and I made a scrivener's error. I said my motion for sanctions, I have no sanction power. This court has the inherent authority and equity that finds this conduct is as outrageous as I do, and it has the ability to sui sponte under Rule 57, Statute 57-105. First paragraph, I believe, gives the court, when they find something, and I believe this is not dissimilar to the Pinot case up there before the Supreme Court. It was involved in both this morning.
Thank you.
Thank you, Judge.
You're welcome. Thank you both.